Be ready. Start. It has further been argued by the learned counsel for the respondent that the withdrawal of the petition filed by the appellant petitioner under section 9 of the Act is suggestive of the fact that he has condoned all the previous acts of alleged cruelty. Stop. After the withdrawal of the said petition wide order dated August 13, 2003, there is no instance of any cruelty brought on record by the appellant or husband. Stop. It is well settled that even though condonation has not been pleaded as a defense by the respondent, stop. Yet it is the duty of the court to find out whether cruelty was condoned, and in the facts and circumstances of the instant case, in view of the order dated August 13, 2003, the husband has already condoned and there is no subsequent instance which could amount to cruelty. Stop. Finally, it was submitted by the learned counsel for the appellant that the impugned judgment and decree dated May 3, 2010 is well reasoned and is absolutely in consonance with the evidence available on the file. Stop. As such, it requires no interference by this court. Stop. Appeal being without merit deserves to be dismissed. Stop. We have given our anxious thought to the rival contentions of the learned counsel for the parties, besides going through the evidence available on the lower court's record. Stop. Undeniably, the marriage of the parties was solemnized on April 13, 2002. Stop. The parties lived together and cohabited. Stop. The respondent wife lived with the appellant husband for a short period after the marriage and ultimately she left and is residing with her parents. Stop. No child was born out of their wedlock. Stop. Under section 13 of the Act, the marriage can be dissolved by a decree of divorce on a petition preferred either by the wife or husband on the ground of cruelty, in case other party after the solemnization of marriage has treated the petitioner with cruelty. Stop. In a large number of cases, the Honorable Apex Court as well as the High Courts have repeatedly stated the meaning and outlined the scope of term cruelty. Stop. In Samar Ghosh, the Honorable Supreme Court set out some illustrious cases where inference of mental cruelty can be inferred. Stop. In Samar Ghosh, this court set out illustrative cases where inference of mental cruelty can be drawn. Stop. This list is obviously not exhaustive because each case presents its own peculiar factual matrix, and existence or otherwise of mental cruelty will have to be judged after applying mind to it. Stop. We must quote the relevant paragraph of Samar Ghosh. Stop. We have reproduced only the instances which are relevant to the present case. Stop. No uniform standard can ever be laid down for guidance, yet we deem it appropriate to enumerate some instances of human behavior which may be relevant in dealing with the cases of mental cruelty. Stop.